Hello, we are live. This is Matthew Newsom, the attorney with Surge Business Law. And once again, I am answering your questions. Thank you for everybody watching this live on YouTube, LinkedIn, or Facebook. If you haven't hit the subscribe or follow button, now is a good time to do that. We have some great questions today. I got a lot of intellectual property and technology-based questions. So if you are into those topics, make sure to watch. And let's jump right in. This question came up when I saw a lawsuit. Tesla is being sued over the full self-driving feature. And the nature of the lawsuit is, what is foreseeable misuse? And you might be able to guess from the name what that means, but foreseeable misuse is when when a company creates a product to do X, and instead somebody tries to use it to do Y. Can the company get sued if something bad happens when person uses it for doing Y, something it wasn't intended to do? And the answer is yes, if it is a foreseeable misuse. So in this case, people are sleeping or sitting in the back seat while their car drives themselves around. And people are suing Tesla because Tesla should have predicted that this is a foreseeable misuse. I don't know if they'll succeed or not. It's a tricky question, definitely a fact-intensive question, but I want you to know that it is possible. I did a little searching around on the internet and I found some examples. And if you want to see just a hilariously tragic series of events, look into lawsuits over foreseeable misuse. But if you want to know just any consumer product, open the manual and look at the first couple pages of all of the warning labels, and you'll get a hint at what are some of the things that people might have done that were foreseeable misuses and the company got sued. Toasters, hair dryers, those are excellent examples. But one example, this is hypothetical, is, imagine that you created oven cleaner to clean the inside of your oven out, and it's a really strong chemical, and somebody uses the oven cleaner and they say, wow, this is so good, I'm going to use it on my windows. And then on their windows, it damages the glass. Could the company making the product sue them for the damage to the glass? And the answer is it's possible. If that company is smart, they're going to have a disclaimer saying, only use on the insides of ovens and only if, these things are true. Don't use on glass, don't use on fabric or whatever. And so disclaimers can help companies avoid lawsuits for foreseeable misuse. But these things happen all of the time. Don't use hair dryers in the bathtub. Somebody made that mistake and now there's a warning label on it. So I guess that is something that the company should have foreseen, is you wanted to get wet and dry at the same time, maybe? So here's a question for you. What are some hilarious examples that you've seen, or maybe tragic examples that you've seen of someone misusing a product and it going badly? So that is foreseeable misuse. It is a serious area. It's actually probably one of the most interesting areas of law. But it is also litigation, and I try to pass that on to other people. It is product liability law, if you want to look into it more. Let's do another question. What are suggestions for somebody who wants to start a partnership business? And I've talked about partnerships a lot. And the reason why is that partnerships, when done wrong, cause lots of problems. However, I don't really talk too much about what happens when partnerships are done right. And you will see some people on the internet, and I believe that Dave Ramsey is one of them, who are opposed to partnerships. And Dave Ramsey, I respect him. He is very black and white in a lot of his opinions. And so I know that a lot of people gravitate and love clear answers. Partnerships are not black and white. They are gray. They can be very bad. They can be very good. And so what should you do if you want to have a successful partnership? First of all, the best partnerships happen when people bring different things to the table. For example, I'll commonly see a partner who is great at sales and a partner who is great at administration. That is a really good combination. One is detail-oriented, one is gregarious and outgoing, and a people person. That's such an excellent combination. Or we will see partnership situations where a partner brings money and another one brings effort or labor or sweat equity, as we call it. and they collaborate and they do something that neither one can do separately from each other. So partnerships absolutely can be good. But some of the things that you should do is, first of all, you should talk to an attorney, and I really, really encourage this, because anyone who's done business law like I have for even just a little while is going to quickly have a list of things that can go wrong. And a lot of people don't understand what we do in law school. In law school, we read lawsuits, tons and tons of lawsuits, way more lawsuits than laws. And so we know how to spot issues. And so if you come and tell us your situation, we can tell you, okay, watch out for this and this and this. Here's what could go wrong. So you should talk to a lawyer. But the lawyer is going to have you do a few things. They're going to ask you probing questions, the kinds of things that lead to conflict later on in the partnership, and then the attorney is going to draft this into an agreement, some kind of partnership agreement that everybody signs, and that will say um, if we can't agree on an important decision, here's how we're going to resolve it. That's a really important situation when you have 50-50 partnerships. Uh, and so you want to talk through all of these difficult questions, and you might say, Matt, what is the list of difficult questions? And the answer is that there's usually two categories of difficult questions. So I'm not going to go into every question, but the two categories are money and power. So for example, money questions: how much money are you going to hold in reserves? How are you going to pay yourselves? How often are you going to pay yourselves? What are you going to do if the business needs money? Do the partners have to chip in? Those are money related questions, and they're a very common source of conflict. And so you'll want to go through a list and work that out before you initiate the partnership. Second, power questions. Power questions really come around decision making. And sometimes people do clever things like 51-49% partnerships. That doesn't actually solve all of the problems. Because imagine this: if you got a 50-50 partnership and one partner wants to do something and the other partner doesn't, well, you're at a standstill, no majority. So the one who doesn't want to do the thing wins. Well, a 51-49% percentage partnership, it doesn't actually solve that problem unless the one who wants to do something is the 51% person. And so it really just kind of kicks the can down and it builds up frustration. And so instead of just trying to do clever 51-49 things, talk to an attorney so that they can help you get creative solutions. And so what we'll do is we'll do different areas of authority. For example, if you have a tie, but it's in hiring, well, then maybe this partner who is in charge of people gets the tiebreaker vote. Or maybe if it's about uh, quality, then this person is in charge of that. And so what we can do is kind of create an agreement and divide up the different roles in the company so that each partner has authority in this area and yields authority in another area. So the best thing that you can do is, first of all, is talk through these problems before they're problems, right? Do it when everyone's happy, when everyone's optimistic. Second of all, you should create a formal business structure. If you don't create a formal business structure, then you get what sometimes is called, especially by me, an accidental partnership. And so you can do a written partnership agreement and you can register it with the state and get a limited liability partnership. Don't do that. Do an LLC. An LLC can do everything a limited partnership or limited liability partnership can do. And it's a very flexible and popular tool. But sometimes a corporation is the right way to go as well, especially if you think your partnership is going to change over time and you're going to add more partners. And so corporations have huge benefits. So once again, talking to an attorney, they'll help you make that decision. But there's two things. Those are the two things that I think you should do to make sure your partnership is successful: is talk through the hard stuff and create a formal partnership business structure like an LLC. And I'll just tell you, everyone out there has got a story. If you don't mind telling me, I'd love to know your questions, but thoughts. Maybe you've seen a partnership fall apart. I can think of one example from before I was attorney. A couple friends, their friendship broke apart because they were business partners, and they were one of those examples why a lot of people say don't do partnerships. I'd like to hear your stories too. Leave them in the comments. A great question. Benefits of subcontractors versus employees. And again, this is another one. Even just 2 weeks ago, when I did my previous live stream, I talked about the problems of each of these. Well, what are the benefits, right? Let's be optimistic. Let's be positive. There are great benefits to both. So if the kind of work that you're doing is something where it is not maybe a core function of the business, and you would expect a person to bring unique expertise, and you want to give them the authority to manage themselves, to do that thing that they're an expert in, they should be a subcontractor. So they're bringing their own knowledge, their own tools, their own processes and systems. That's a great type of project to hire out to a subcontractor. And in fact, many consultants would qualify as this type of a subcontractor relationship, because if you're hiring a consultant, you want someone who's got special expertise that they're going to bring to your team, maybe temporarily, maybe for a long time. But that would be an example of a subcontractor. This person brings something unique and special, and they are going to have a degree of autonomy to your team. One of the benefits is that you can decide at any time when to break up that relationship. And contractors not being employees, as long as you've got like a written agreement that provides for this to happen, then that can end. And in fact, a lot of companies will hire contract help, knowing that this area of the business might fluctuate and their demand for help might change. The contractors tend to get paid a little better than employees, but they sacrifice job security. What about employees? What are the benefits of employees? Well, the first and foremost one, and this is a little bit of a foretaste into another question coming up, but employees have a duty of loyalty to the company. And so if you have an employee who works for you, then that employee is not really allowed to work for a competitor. So if you've got a Burger King and your employee works for you at Burger King, well, they can't really work at McDonald's too. So you get that duty of loyalty. Also, too, one of the differences and one of the ways we assess whether a person is a contractor or an employee is what degree of control the boss has over the worker. And if they have and want a high degree of control, then that implies that they should probably be an employee. And so that's one of the benefits, is if you have an employee, you get that high degree of control. And again, this is a little bit of a foreshadowing for another question. The employer also owns the intellectual property and the creative work and creative output of your employee, without needing extra contractual language, whereas contractors would need a work for hire clause for that to happen. So there are a lot of benefits to employees, and those are things that you should factor in. But a lot of companies, they think that contractors are better because they're easier, and that's really not true. I think that more companies should be more brave about bringing on their staff as employees, because there are tremendous benefits to doing that. Should I put the phrase attorney-client privileged and confidential at the top of my emails? So leave me a thumbs up or leave me a comment if you have ever included this in an email. And and so this was suggested by someone in a chat room that I'm in, and they we worked for the same company in the past, and there was kind of a policy to include this in certain kinds of messages. Why? Why would you do that? When would you do that? This message is most useful when you do not want what you are about to say to be considered evidence in a lawsuit. All right. And so when you hire me as an attorney, you sign a representation agreement, and that representation agreement creates an attorney client privilege. And then when you are talking to me about situations that we think could lead to a lawsuit, that communication cannot be used as evidence against you if it does become a lawsuit. That's when it's helpful. Sometimes people abuse this and they attach it to every email. And in fact, there was a famous lawsuit against a major technology company in the last 18 months where they got dinged by the court because they were just throwing that message, that phrasing into everything that they did. So that will not do what you want it to do if you're just trying to keep your emails and stuff out of court. So it is only useful if you have a reasonable suspicion that this communication could be related to a pending or existing lawsuit, and it's relevant to that lawsuit, and you do not want it to be included as evidence. So uh, that would invoke your attorney-client privilege. Should you do it on every email? No. Should you do it in every email to your attorney? I would say go ahead and go ahead. And then what happens is if you do get sued, they're going to say, we want every email, and we're going to hold back anything that has that attorney-client privilege statement in there. But then they might say, well, we don't think that that is really appropriate. And so then what's going to happen is a magistrate, which is kind of like a lower ranked judge, will review that to see if it is actually attorney-client privilege or not. That way it can't be used as evidence. But it's possible that in a disputed case, the other party could see the contents of that email. They just can't mention it in court. So there you go. Should you use it? Yeah, when the time is right. And in fact, if you communicate with me or my team, it is included in every email to us by default, just as a precautionary statement. But it's not a bad idea because it's only included there in replies, not messages originating from you. All right, let's do another one. How to protect my local business if a competitor with a similar name moves into my state? This is a very specific question because I put in here the word local business. And so that automatically reduces some of the obvious answers to this question. If I did not say local business, then what we would do is we would say you need to protect your brand with a federal trademark. Registering a federal trademark gives you a lot of protection. But this is not a international or multi-state or interstate business. This is a local business. And because they're only doing business in one state, they're not likely going to qualify for federal trademark protection. And so how does a local business protect their name from a similarly named company moving into the state? First of all, I just want to remind you that trademarks protect you from confusingly similar uses, whereas copyright protects copying. Trademark does not require an identical usage. And the classic example was a 1990s movie called Coming to America with Eddie Murphy. And in that movie, the supporting actress's dad ran a fast food restaurant called McDougal's, and it had a goldish green arch instead of the typical McDonald's golden arch. And McDonald's was constantly going after them for trademark infringement. And he was always saying, well, no, 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 it's not a golden arch, it's a golden green arc. And the fact is that's not a strong defense because trademarks protect confusingly similar uses. And so you might be able to go get a dumpster and paint it green and yellow and not put the word waste management on there. But I suspect the people at Waste Management would say you're causing trademark problems there. So trademarks protect against confusingly similar uses, not exact matches. And so you could have ABC company and they would probably defend against a company called ABCD company. Say, well, it's not the same. It's not exactly the same. Well, it's confusingly similar. Okay, so how does a local brand protect it? They protect it with a state trademark registration. And so we commonly, this is the geeky term, we commonly call that a common law trademark. Common law trademarks do not give nearly as strong protection as federal trademarks, but they do provide protection. And so they are absolutely a useful thing to use if you are building a brand and you intend to stay local. But a lot of the same rules apply. It's still got to be not too descriptive and not too generic. You still have to have good faith first usage. And so if you know a company in the next state over is using the same name, then that's not good faith. That trademark, you'll register it, but it won't help you if you need to defend it. You do need to stop other people from using the name if you find out someone local is using it. And I've had that happen. And so we've seen people start businesses with the same name. And so you need to have your attorney send a cease and desist for you. So you still have to go through all of those steps. The registration process is a lot simpler. The registration cost is a lot lower. And the time to register is drastically lower. And so in Iowa, instead of 12 to 16 months for a federal registered trademark, it can be a couple days to get a local state registration. So it is cheaper, faster, and simpler. But I do suggest still having an attorney help you with this. It's way more affordable to do a local registration, but again, it's also a little bit harder to protect against. That's what you should do. File a local trademark. Uh, Make sure that it's a good faith filing, and then defend your trademark so that you know that people aren't using it. And so, tell me, have you seen a local brand using a trademark in an inappropriate way? I love seeing people will send me screenshots and video clips or examples of people abusing or misusing a trademark. I love to see the examples that you have to share. All right, I said earlier, a little bit of foreshadowing. What happens if an employee violates their duty of loyalty by working for a competitor? So, one of the benefits of having an employee instead of a contractor is that you have an expectation of loyalty. I said before, if you run Burger King, they can't work for McDonald's. That would be a breach of their duty of loyalty. So, what can you do if a company either A, goes and works for a competitor while working for you, or they do something that would be benefiting a competitor while working for you? So, for example, downloading your list of customers and giving it to your friend who runs a competing business, or using it in their own business. Maybe they start up a competing business on the side. So, that's the specific example for this case. And the answer is that, first of all, you need to use your company's policy for termination proceedings. And so you need to discipline them, you need to do it in writing, and you need to follow your process for termination. And you need to decide, is this something urgent that you need to do? Because I'm going to say in most cases it probably is. Your company should have a written predefined process for what to do with employee discipline issues. This is no different than if they were doing something harmful in the office. They were harassing an employee or something like that. You need to take it very seriously, and up to and including termination. But in this case, you're not limited only to that. Now, you might be able to press charges and have them thrown in jail, but that is very unlikely, very unlikely. But instead, if your business suffers a monetary loss because of this, then you can sue and not only get your loss. And so let's just say that that they take a $10,000 customer and give it to a competitor, and so now you lose $10,000. You can sue for that. You can also sue for punitive damages. And punitive damages are what make lawyers' eyes light up, because that's where you can go after a person for big money, not just the actual amount lost, but say, hey, they screwed up. When people talk about that McDonald's coffee incident where the lady spilled the coffee on their lap, that $1 million lawsuit was mostly punitive damages. And that lawsuit was more nuanced than a lot of people think. But the point is, punitive damages can bring up a judgment. Now, do you really want to sue your own employees? And the answer is it can be necessary, especially in a situation where you've got maybe a high-ranking employee like a vice president or something. That would be an example of a case where you could go after them pretty seriously. Now, I want to be clear that I'm not talking about non-competes, okay? Non-competes are a very different, very tricky subject, and I've talked about them in past videos. Please go back and look at the past videos. Non-competes are also growing increasingly disfavored. That's kind of a inverted logic there. But more and more states are saying no to non-competes. That's why I'm not talking about non-competes. This is a duty of loyalty, a breach of the duty of loyalty. This is not affected by your state's opinion on non-competes. Yes, it does give you some rights. So if you're an employee, please be careful. Give your employer the respect that they're legally entitled to. And if you don't like your employer, quit. Go somewhere else. Okay, let's do the next one. I've answered this question before, and it is so important that they just keep asking it. So I'm going to do it again. Does my employer actually own my software projects outside of work? There are 4 answers to this. Yes, yes, maybe, and no. And so if you have an employee-employer relationship, not a contractor relationship, if you have an employee relationship and your employment agreement is silent on this subject, then the answer is yes. Then your employer does own the software projects that you create outside of work. If you are a contractor and your contractor agreement has a work for hire clause and is silent on the matter of pre-existing intellectual property, then yes, the employer does own the software and other creative things that you've done outside of work. And that is whether they're done on company resources or your own resources. So just because you close the lid on the company laptop and go hop onto your own computer, if you're an employee, then they own that intellectual property. If you have an employment agreement that talks about intellectual property ownership, then maybe, because in that case, the employee agreement that you signed dictates it. And so a lot of companies will allow you to create exceptions. This is especially true of high-tech companies where they can give you an opportunity to disclose intellectual property that you created outside of work before being hired, and then they can provide exceptions that allow you to do things that make contributions to that work while you're an employee without those contributions being owned by the employer. And some bigger tech companies actually have a compliance process that you can do to ask for permission. And that is an important point. You're going to hear me say it again in this live stream. If in doubt about copyright, which is what we're talking about here, ask for permission. Ask for permission. And so I have a client who is a researcher at a university, and so he had an invention, and I said, ask for permission. And he did, and he got a written agreement from the university that allowed him to get the kind of exception that he wanted. And of course, it took a little negotiating, but ask, and get it in writing, and then you can do whatever you want. And then lastly, I said the fourth answer is no. If you are a contractor and you do not have a work for hire clause in your agreement, then the default is that you own all of the creative work that you've done. This actually hurts employers sometimes. And in fact, and I've seen a lot of companies hire a graphic designer to make a logo or a brochure, and it's just a handshake agreement, or they use a contractor agreement that does not have a work for hire clause. And then they find out that they don't actually own their own logo. This is a very serious and common problem, but companies will sometimes forget to include a work for hire clause in a contract or a contractor agreement, and then they don't own the IP that they paid for. And so in that case, you need to get a copyright assignment. Call me and I'll help you with that. So out of curiosity, how many of you have worked on a project outside of work and you think, could this be an issue? You might not want to disclose that. Maybe you do, but I'd love to hear from you. So at the very least, hit the like button on this video so that I know you're out there. All right, let's do the next question. I developed software at a previous job. How long should I wait before doing work on a similar field or contributing to open source? And I'm gonna just tell you this is a very unsatisfying answer, and that is there is no right answer to this question other than ask for permission. Because what goes on is if you look inside your employer's software and you see how it works, then you have loaded that into your brain. You can then go a month later and spit out something that might accidentally be a derivative work. And in that case, whatever you create could be partially owned by your employer. And back in the fall on a previous AMA video, I talked about derivative works a little bit, and I gave the example of when Compaq invented the first PC clone. IBM owned the little BIOS chips and the intellectual property on the BIOS chips, and lots of companies had downloaded the BIOS software and created copies. That's a derivative product, and that's what we call now software piracy. And so that was not allowed. But Compaq, which is now HP, they, instead of looking at the source code on the BIOS chip, they tested it and they said, okay, when we do this, it does that. And when we do this, it does that. They did a black box reverse engineering. So they never saw the source code, and therefore they were never able to create an exact copy of the copyrighted content on that BIOS chip. And when IBM sued them, Compaq won, and so became the PC clone market. And other companies created PC clones that did not use IBM's intellectual property, but were compatible with it. So if you've seen the source code, then you cannot go and create something that's similar without having a fear that it might be considered a derivative product. And so imagine this, you're working for a company and you see their secret sauce, and then 6 months later you go create a company and you say, I'm not going to use any of the source code, but you create something that is remarkably similar, and then you sell your company for $100 million. Guess what? Your previous employer might say, hey, we own that. And then ouch, you're in big deep doo-doo. So you do not have a satisfying solution to this other than getting a written permission from your employer to be released from your claims. And guess what? Employers do this. They do that. And so it usually doesn't hurt to ask. And so you just have to give them some assurances. And so you know what happens if you don't ask, you don't receive. So give it a try, ask for permission. If in doubt, then you're going to have the burden of proof of trying to show that what you created is not a derivative product. Sorry that that's not very satisfying to you, but it is a simple truth. Similar question to the last one. At a previous employer, I created a library of tools, but did not open source them. And the person who asked me this question and asked to be anonymous said that the company was actually in the process of open sourcing them and then abandoned that process when this employee left. Can I create an open source equivalent now that I've left? And so you've heard me say this once, but it's okay for me to say it again. The only way to be sure is to ask for permission. And if your previous employer was already willing to open source it, they might even willingly give you permission to continue that process after you've left, and you don't have to rewrite it. A lot of companies like the goodwill that is associated with open sourcing something. And so you might be able to work with them to finish that process of open sourcing your software. Good, do it. But if you can't, then you're going to run into that classic problem of possibly creating a derivative product. And a derivative product means that part of the copyright belongs to your previous employer, and part of the copyright is the new original stuff that belongs to you. And it's kind of like when you buy a house, you want clear title. And in this case, the software you've created doesn't really have a clear ownership because part of it is owned by different people. And that's a problem. You can take your chances, but the only way to be safe is to ask your previous employer who owns the copyright to that content for permission to either create a new product from scratch or to maybe complete that process of open sourcing that tool. If you don't mind me asking you, I'd love to know, is there a favorite open source tool that started out as an internal project? And so I'd love to know, what kinds of tools have come out because of it that you like. I've seen numerous and used numerous projects over my career as a lawyer and before as a software developer. And so I'd love to hear your thoughts on cool things that started out as an internal project and are now open source. That would be inspiring to the audience so that they can see that this does happen. Will using Apache 2.0 licensed software in my project impact my patent or ability to sell my project? And there are a lot of discussions on the internet about the Apache 2 license and its patent protections. That is not what this question is about. In this case, a person has developed a product and patented it, and then they want to enhance that product by using software or other resources that have been released under an Apache 2 license. An Apache 2 license is a very business-friendly license that does not put a great burden on companies who use the Apache 2 license in their own software. And so it is an attribution license. It does require you to disclose the software that you're using and that software is an Apache 2 license, but otherwise does not require you to push back your changes to the community that created the software or to open source your own software. The Apache 2 license does have a patent license clause in it, which basically means that if you contribute a project or code under an Apache 2 license, then you also agree that if you have a patent on that code, that people can use that code without fear of infringing on your patent. And so that is a deal breaker for some companies who like to open source the code and keep the patent as a way to commercialize their product. So the Apache 2 license has an explicit patent license included in it. That patent license only covers the open source software or component that you are using. It does not transfer to the software or the product that you're creating. So the Apache 2 license software does not change your rights on your own patented material. If you release your material under an Apache 2 license, then that patent clause affects you. But you can use the Apache 2 license under the terms of the license without fear that your patented technology will then become some kind of publicly usable product. So yes, please use the Apache 2 license. It's great for this purpose. And it is also a very, very practical and great license for anyone releasing open source software if you want to reach the broadest audience out there. So what's your favorite Apache 2 license software? I'd love to hear about it. I for many, many years used the Apache HTTP server. And so that is the classic example that I always think of with the Apache software license. But it's such a popular license that's used in many tools. Which one do you like? Last question. I put this one on the list. This is very dear to my heart. When people ask me what I do, I say I run a law firm that focuses on business risk management. What is risk management? I want you to understand my core philosophy. Founders, business owners, leaders in companies need to take risks. When I worked for John Deere, one of the attorneys there was in a meeting and I was there and somebody said, well, let's wait until he's okay with it. And that attorney said, stop. If you wait until the lawyers are okay with it, you'll never release a product. I love that statement. I'll always remember it. And it was very inspiring to me as I went into my own practice. And so businesses need to take chances. You can never make everything perfectly okay. When you work with me, I will reassure you. And that's where risk management comes in. Risk management is not risk avoidance. And in fact, profit follows risk. Your greatest chance of profiting comes when you take risks, when you take chances. And so don't play it safe, take chances. But here's how you take the edge off of those risks. You should create a risk management plan. And that is think about what if, what could go wrong? And then sometimes your imagination will go wild and you'll think of all of these crazy things. And then you can ask yourself, well, what's the chance that that will go wrong? And you might often find, and in fact, you will often find, that probably won't happen. All right, so can we insure against that risk? Can we do something else to soften the blow if that happens? But what are the things that are likely to happen? And then you can create plans. So for example, I see companies who use open source software in their new software startup company, and they want one day to be acquired, but they don't think about, is this software something that will hinder my company's ability to be acquired by a larger company? And the answer is it very commonly does happen. And so if you're using AGPL software or the business source license or something like that, these things will hinder your ability to get acquired at a later time. And so you can make a plan. How can we get done what we want to do without interrupting or preventing our ability to be acquired at a later time? And so that's where a risk management plan comes in. And so what we do is we look at risks and say, okay, is this a good risk? Is it going to pay off well? Buying Bitcoin, is that a good risk? Is it going to pay off? Who knows, right? Putting my money in the stock market, is that a good risk? Is it going to pay off? Who knows? I can't tell you the answers to that. Using this open source library, hiring this salesperson, expanding to a new location. These are things that we can talk about and say, okay, these kinds of risks could pay off. Maybe they will, maybe they won't. Here's the costs, here's what to happen. And so my firm helps businesses like yours do risk management. And so we create a matrix of the different kinds of risks. What could happen if they go bad? What could happen if they go right? What the costs are to mitigate. And then we help you make the decision. And so that way you can take the kinds of risks that help move your business forward and avoid the risks that have a low likelihood of return and will just cause problems down the road. That's what risk management is. And maybe I'm sounding a little excited. It's because I do actually love risk management. It was my favorite class in business school when I was in undergrad. And so I would love to help your business identify and manage its risks. And I believe that my legal and technology background would help me do so. So please give me a call. And with that, we are done. Subscribe, hit that subscribe button, hit that like button. Let me know that you're watching. Send me your questions so that I can include them in future videos. And with that, we'll call this meeting a wrap. Have a great day.